this idea of funding. In Everson, we talked about transportation, Board of Education, we have textbooks. In the other two cases, we have providing facilities and providing funding to groups involved in religious activities. In this one, we're going to talk about something that is extremely controversial even today. In Zellman versus, anybody ever hear this case? Zellman versus Simmons-Harris? In Zellman versus Simmons-Harris involves a project in the state of Ohio. The Cleveland School District is one of the most underperforming school districts in the state. Less than 18% of the people in 3rd to 5th grade actually pass proficiency tests. 2/3 of the students, when they reach appropriate age to graduate from high school, do not graduate. This is an extremely underperforming school district. So the state institutes a pilot program saying that any parents want to take their kids and move them out into affiliated schools with the program, they will get a $2,500 voucher. This is a means test saying that we will give you a credit to send your students to a school. 86% of the schools that apply for this program are religiously affiliated schools. Out of the students that participate and qualify, they have to be under a certain income for the family. Out of the students that actually qualify, 96.8% of the ones that qualify and do take part in the program choose to go to a religiously affiliated school. Simmons-Harris is a mother of one of the children that stayed in the local school district, and she's going to sue the administrator of the program in the state of Ohio, Mrs. Zellman. In this particular case, she's going to make the case that this is a violation of the Establishment Clause of the First Amendment, which essentially says that it's encouraging students with a $2,500 credit to go to a religiously affiliated school. Now, in this particular case, obviously they have to find the religious angle in order to get it into the Supreme Court. What else might be at issue here? What do you think? Besides just the fact that, well, if you're a parent living in the school district and your student stands a 66% chance of not graduating college, why might you want to send your student to a religiously affiliated school? What do you think they're doing there that they're not doing in the Cleveland public school districts?
Better education. Better education.
Okay. What else? They're wrapping their knuckles?
Better
Educating.
They're educating them, right? And I know in many of the local public schools around the Cleveland School District, they have a 97 to 98% graduation rate. Why? Because the parents are spending $7,000 to $10,000 per year, per school year, to send their children there. With a $2,500 credit, this might encourage some of them to go there. But what else is at issue here is the fact that if you have an underperforming school district and parents have the opportunity to send their children elsewhere, they may take advantage of it. And many of them do. What does that do to local funding in the local school? Well, that's the art of competition, right? In this particular case, Simmons-Harris is going to also argue that the tax base of the local school is being evaporated. Well, the argument would be made also, well, if your teachers were educating the students, they wouldn't be fleeing the school district. If you had a performing school district, many students wouldn't leave. They would stay there. So in this particular case, you have the religious aspect, but you also have the side issues of teachers trying to protect their jobs and superintendents trying to protect their jobs as well. In this particular case, the Supreme Court, in a 5-4 decision in 2002, says that the program does have a valid secular purpose. And what is that valid secular purpose? Educating the kids, exactly. Of providing educational assistance to poor children in a demonstratively failing public school system. In the Board of Education versus Allen and in the Everson case, they could make the case, hey, yeah, we're driving the kids to the door, but once they're at the door, they're on their own. In the textbook case, Board of Education versus Allen, they get every textbook, science, math, social studies, except which one? The one involving religion, absolutely. Any of you in here that may have had children that went to instead of a local public school, that went to a private school, you go to Umpqua and you pick up your books, and they give you every book except which one? Except the Bible or the religiously affiliated textbook. The first day you get to Holy Trinity High School, they hand that to you. Believe me, I know. Same thing with driving to the local school district. Massapequa School District, if you live here, has to get you to the door of the school, according to the Everson case. They have to provide you with safe transportation. Why? First of all, because you are a taxpayer here, and just because you're not using the other services in the town, they do have to provide you with some services. The other reason, because the local school district has the obligation of providing you with safe transportation. Now, when they got you to the door of the school, if the bus driver, who is paid for out of the Massapequa school budget by the Massapequa School District, held your hand, walked you to the chapel in the center of the school, told you to kneel down and pray before you start your day, then we might have some type of religious conflict here. But according to the Supreme Court, the fact that they got you to the door, what happened to you beyond that door in terms of religious education had nothing to do with the state whatsoever. Same thing with Zellman versus Simmons-Harris. But we're seeing it extended. Now we're seeing it extended to religious education. But so this is going to become extremely controversial from 2002 going forward. The idea that first we were just talking about transportation and books, then we're talking about spaces and after-school activities, then we're talking about funding of after-school programs, now we're talking about the actual education itself would get a credit from the government, from taxpayers essentially. Ohio gets around this pretty cleverly. What do? They take the voucher, or they take the credit, or they take the scholarship, and instead of giving it directly to the school, they give it to the parent. This way the parent gets to decide where the credit goes, not the government. So in that way, they kind of get around the idea that the government is funding religious education. They say, no, we're giving money back to a taxpayer, and the taxpayer is deciding where they're going to bring that money. And this also brings in the principles of private choice, the idea that the person, once they get the credit, will essentially be deciding where the money will go. Another case we have is Engel versus Vitale, not controversial at all. This involves school prayer, just getting very controversial. 1962, the Supreme Court will weigh in on a New York State law that will essentially be looking at school prayer. In New York State, they had passed a law at the Board of Regents in 1951 stating that the school day will begin with a mandatory prayer. The prayer was mandatory that the school read the prayer, but it was a voluntary prayer. If you wanted to recite it, if you wanted to be part of it, that was your option. If you wanted to walk out of the room, that was your option. And it was a non-denominational prayer. What does that mean? Well, here's what the prayer actually was. Almighty God, we acknowledge our dependence upon Thee, and we beg Thy blessings upon us, our parents, our teachers, and our country. Amen. Now, when I talk to 18-year-olds about a non-denominational prayer, they say, well, that mentions God. I say, yes, but it doesn't say Almighty God and baby Jesus. We acknowledge upon Thee, Son of Man, who walked on earth until He was 33. We don't do that whole, that's obviously talking about one specific faith. By referencing God, if you believe in any faith, you have a belief in some God. So they call that a non-denominational prayer. So it's non-denominational, and it's a voluntary prayer. What do you think the Supreme Court says about this? Anybody that's been in a classroom after 1962 can answer this? And I ask all my students, how many of you started your day with a school prayer? And none of them raised their hand. I said, well, you know the outcome of this case, right? Almighty God, we acknowledge our dependence upon Thee. We know where this is going. The Supreme Court is going to say, we think that by using its public school system to encourage recitation of the Regent's Prayer, the state of New York has adopted a practice wholly inconsistent with the Establishment Clause. They're saying, essentially, in this 1962 case, they changed the definition of the First Amendment. The First Amendment talks about the establishment of religion. Now, when we look at that prayer, is it the establishment of religion? If you interpret it to mean establishment means creating a government religion. Are they creating a religion here? No. Are they prohibiting someone's free exercise? It's a voluntary prayer. You could walk out of the room. But we need other words to define what this actually means, because these two don't apply in this particular case. So how is it a violation of the First Amendment? Well, what they do is they actually change the definition of establishment to actually mean also encouragement. So they are not establishing religion, but the Supreme Court is going to make the case that they are encouraging religion. And by encouraging religion, they are essentially promoting the practice of establishing religion. So the Supreme Court is going to say, we think, there can, of course, be no doubt that New York's program of daily confession, invocation of God's blessings, as prescribed in the Regent's Prayer, is a religious activity. This is one of the most controversial cases in the past 50 years. Even today, many people in this country, a majority of people in this country, do believe, I mean, you might not know this living here in New New York, but many people around the country actually believe that they should start with a prayer. This is one of the most frequently cited cases where people are going to challenge their congressmen and their senators to pass an amendment to actually overturn this. Extremely controversial. By the way, what's going on in 1962? Who's in the White House? John F. Kennedy. And only 2 years before, John F. Kennedy had run on a campaign really to get under this cloud that people believe that he would not listen to the Constitution but take his orders from the Pope in the Vatican. So this is extremely controversial because John F. Kennedy, the sitting president, running potentially in the next 2 years for re-election, has to now weigh in on this. It's going to be not only controversial in our own classrooms and our schools around our neighborhoods, but in the political climate at the time, it's going to be extremely controversial as well. This case, Marsh v. Chambers, is going to revisit almost the same issue. In Nebraska, Nebraska is one of the only states in the country that has a unicameral legislature, which means they only have one house making their laws in the state of Nebraska. This man, Ernest Chambers, is going to challenge the chaplaincy practice in the state of Nebraska. The chaplaincy practice meant that their legislative session would begin with a prayer. Voluntary, again, non-denominational, similar to the previous case. He's going to sue a man named Marsh, who's the treasurer of the state of Nebraska, because he's the guy whose name is at the bottom of the check to the chaplain saying the prayer. So he's going to sue on the grounds that because taxpayer dollars are going to this chaplain to say a prayer in a government building, it's a violation of the Establishment Clause. Establishment, as we said in Engel versus Vitale, equals also encouragement. So just the fact that this government institution is encouraging prayer, it's a violation of the Establishment Clause. Anybody know, if we look at Engel versus Vitale as our precedent, who wins this case? Who? Chambers. Chambers is the guy in the state legislature who doesn't want the prayer. He thinks it's a violation of the Establishment Clause. Chambers actually loses this case. Chambers is going to use Engel as the precedent, but the Supreme Court is going to almost completely ignore Engel as precedent in the case. What are they going to go with? They're going to say from the colonial times to the founding of the Republic and ever since, the practice of legislative prayer has coexisted with the principles of disestablishment and religious freedom. They're going to use the idea that there's a tradition that we start the legislative session with prayer. Well, couldn't they say the same thing in Engel versus Vitale? There's a tradition that we start our school day with a prayer. They completely ignore that. There's another clause that's a little bit different. They seem almost simultaneous. You have a religious institution, you have a state institution, with a prayer, non-denominational prayer, voluntary starting their day. The difference also in the two cases is the fact that in Engel versus Vitale, look at the audience. The audience is young children it is mandated that they be there. There's no mandatory submission to sitting there for Ernest Chambers. Ernest Chambers, different from the school kids, ran for election, probably ran in a primary. After he ran in a primary, he ran probably in a contested general election, and then he got elected, then he went there and said, wow, I jumped through all these hurdles to get here, to say, wow, now that I'm here, and after I jumped through all these hurdles, I'm really uncomfortable. Very, very different from the school kids. In the school kids case, the court is going to make the case that they're mandated to be there. Ernest Chambers is not mandated to be there. On many of the cases involving the Establishment Clause of the First Amendment, what we're going to see is the idea that this idea of tradition is going to be something that is upheld over and over again. The Supreme Court, by the way, anybody know how they start every one of their sessions? The prayer. Oyez, oyez, oyez. May God save the United States and this honorable court. Reference to God above the Senate.
Excuse me.
Yes, sir.
The Regis one, you said that was started in 1951, the prayer?
Yes, that particular prayer was written in...
Right, but this was saying going back to colonial times.
Right.
So, you know what I'm saying? That case was brought in 62.
Right.
So you talk 51 to 62. This one's talking for colonial.
Well, in New York, it was written in 1951, but the tradition of school prayer before that had pre-existed in places other than New York.
The point I'm trying to make is
Yes,
that
sir.
they're two totally different cases. I mean, a tradition isn't 11 years.
Sure.
So,
Well, the tradition is more than that specific prayer. The tradition is starting the day with a prayer. The challenge in that case was that specific school prayer,
Right, okay.
right? So.
Oh, okay, I got you.
Yeah,
Right.
people that went to school in 1950 heard a different prayer in different places.
Okay.
It's just that prayer was instituted in 51. And tradition actually is whatever the court says it is. It's not, if they say, well, we've been doing this for 3 months, that's our new tradition, the court has a lot of power. And then if we don't like it, vote them out. Oh, no, wait, we can't do that. This other case is going to be another important one, actually the way that we started this session here tonight. The Elk Grove Unified School District versus Newdow. This one you're going to enjoy. Elk Grove School Down. Michael Newdow is an atheist, and he has a daughter in the kindergarten in the Elk Grove Unified School District. He's going to sue on her behalf, basically saying that the words under God in the pledge, although they are voluntary, although she is not mandated to say it, although she could sit down during the pledge, she could walk out of the room, just the fact that the other students in the class are saying under God in the Pledge of Allegiance is an undue burden to her. Now, under God is added into the Pledge of Allegiance in the mid-1950s by Congress. It really is added initially as a way to, in one aspect, as a way to kind of combat what they call the godlessness of communism. We're going to even include this in our pledge. But it also obviously has a religious reference as well, and a traditional reference to the traditions of our country being founded on the premise of divine providence and things like that, as we see in documents like the Declaration of Independence and other founding documents. So the Elk Grove Unified School District is going to be sued by Mr. Newdow. Now, anybody know how this case actually winds up? Do we have under God in the pledge in our schools? Are we allowed to say it? Okay, some yes, some no. Newdow lost.
Yeah, we do.
Who doesn't have standing?
What's that?
Who doesn't have standing?
Didn't have standing, okay? The Supreme Court kind of punts this one. What do they say? They don't answer the question whether under God is actually allowed in the pledge or not. What they actually say is, in our view, it is improper for the federal courts to entertain a claim by a plaintiff whose standing to sue is founded on family law rights that are in dispute. Now, Newdow, while this was his daughter, he was involved in a custody battle over her, and she was actually, her legal rights and her educational future were to be determined by the mother of the child. In the contract between him and his ex-wife or ex-common law wife, he didn't have standing. He didn't have any custody over his daughter in terms of her educational future or the legal disputes that would go on in the future over her. Now, in this particular case, the Supreme Court, instead of saying whether under God is allowed or not, said that you can't sue on her behalf, essentially is what they said. So the question was never answered by the Supreme Court whether or not under God is allowed or not in the pledge. Now, you might think that they did punt it in some ways, like I said, but actually what they did was the correct move. Because if you take a look at it, if Mr. Newdow, if they were able to answer this question, it essentially would have set up a precedent beyond under God in the Pledge of Allegiance. It would have set up the precedent that you could sue on behalf of somebody that you do not have any claim in the case. So I observe someone walking up here trip over the curb, and even though I don't represent you in any way, I say I'm going to sue on your behalf. And I could cite Elk Grove Unified School District versus Newdow, saying I could sue on behalf of somebody that I have no legal standing to sue on their behalf. So there are some side issues involved with these things as well. So essentially, what we're talking about here now in my class, when we talk about freedom of religion, we spend like a couple weeks on this. So I kind of just tried to race through it a little bit so that I wouldn't put the entire room to sleep entirely. But essentially, what we're looking at here is the idea of religion in the Constitution. One thing that we see about the idea of religion is that we have become more and more tolerant over time of other faiths. You look at the year 1960, John F. Kennedy is elected Roman Catholic, first Roman Catholic president. Only 40 years before that, Al Smith, many people actually say that that was one of the reasons why he did not get elected. In the year 2000, Al Gore and his running mate, partly on the strength of his running mate, I'd say mostly on the strength of his running mate, Joe Lieberman, receives more votes in the presidential election than George W. Bush. Joe Lieberman is the first candidate for national office to be of the Jewish faith. In 2001, in the aftermath of the 9/11 attacks, We not only do not see widespread condemnation of the entire Muslim faith. George W. Bush, one of the first moves that he does in the aftermath of that, I believe the day after, is to visit a mosque and put his arms around the imam. So we do see a toleration in this country that you do not see in many other places. We do not see the religious wars that have existed in many other places. Where do we resolve most of our disputes or issues over religion? We tend to go to the courts. And after the courts weigh in, even though Engel versus Vitale, school prayer is extremely contested even today, and many people have a big problem with that decision, we're not fighting in the streets over it. So the idea of toleration and religion and the Constitution, the founders obviously have laid the groundwork for issues that are still being debated. We talked about 10 cases that have taken place from 1879 all the way up until, was it 2005? And most of the cases, and the cases that we're talking about, are over 16 words in the Constitution. So it's pretty interesting that some of these things we are still debating. We will still be debating them, and many of them are still unresolved, but some of them have been resolved.
There was one other case that you might give some consideration to, the one about the Bible. Wasn't that stricken from the schools?
Yes, that was the Shemp versus the Abington School District. The same way that they held in the Engel versus Vitale case, it was almost the same case, but the issue was Bible recitation in class, and the teacher could actually select the passage. It was almost the same outcome, same idea that the teacher is encouraging religion, the teacher is an institution of the state or a representative of the state. There are a lot of cases that we could have put in here. I did not even scratch the surface of religion in the Constitution. The idea of a prayer during a school event, during graduation, the fact a nativity scene in town hall, whether or not these things are constitutional. In no way would I ever come in here. I'm still learning about the Constitution myself. I like finding groups of people that like talking about the Constitution. Like I had said before, if I said we're going to talk about religion and the Constitution, if I came up in here and surprised any other group somewhere on Long Island, the room would be probably cleared out. But it's nice to be able to come out and spend a little bit of time talking to people that are interested in these things and have some involvement in it. We didn't even scratch the surface, even though the idea of religion in the Constitution, really many of all the way up until Cantwell in 1940, there's only 5 cases involving religion and the Constitution in the Supreme Court. After the 1940s, that's when we see most of the cases, predominantly many of the cases, are going to come out of that, after the aftermath of that Cantwell case. What we're also going to see is many of them is going to be over that establishment idea. Where is that line? A couple of words that we never saw in the Constitution. There's a reason why I went through the Constitution. Many of my students immediately put up their hand and say, well, what about the wall of separation? In those words. Remember Christine O'Donnell when she said in the campaign, no, the separation of church-state isn't in the Constitution. You remember what the crowd did?
They laughed.
They laughed. And anybody see what was on the sign behind her? She was in a law school. These were first-year law students. Okay, I didn't go to law school. I did most of my graduate studies involving the U.S. Constitution, and I'm just interested in the subject. First-year law students laughed at the idea that separation of church and state is not in the Constitution. Did anybody see those words at all? No, it's an interpretation by the Supreme Court. Sir?
On the Cleveland case, where the voucher system won,
Right.
recently, or since Obama's elected, they pulled the voucher system in Washington, D.C. Has
Okay.
anybody contested that, or?
Well, it's up to the state or the school district or the locality to determine whether or not they're going to institute it. That is not a forced program. It's simply a program that is instituted by Cleveland, and then it's going to be contested in the court. It doesn't mean that every district has to adopt that system. So
They
I'm not
had
sure.
it, and parents were very unhappy when it was pulled.
Right.
Something like 1,500 children were forced into a failing public school system. So I was just wondering if any of them.
They may challenge it in terms of getting it initiated or addressing that to their members of their city council, but the court issue over whether they are obligated, the city or state or school district, to give the funding. That hasn't really been addressed at the Supreme Court level. And I haven't heard anybody trying to take that up at the Supreme Court level.
Being that the Constitution is outdated, so they're saying, do you foresee any changes with taking God out of it?
Well, they
You know, because they're
updated-
saying it's outdated, they want to revise it, which I don't believe.
Right.
Do you see that in the future, some people in our leaders would take this out?
Take under God out? Well, they would, the Supreme Court could essentially rule that under God has to be stricken from the pledge. That could be done.
Not the pledge, the Constitution I'm talking about.
Yeah, you got through legislation, right?
Well, to amend the Constitution, you have to go, it could be done, yeah. You can go through the amendment process of Article 5. Essentially, you have to go through both houses of Congress, you have to go through 3/4 of the states. You could pass an amendment essentially transforming the words of the Constitution, absolutely. It could be done, but it would take more than just presidential action or congressional action. You would have to a large number of states. That's why it's so infrequent that the Constitution has been changed.
I think the real issue is not so much what's in the Constitution, is who's sitting on the bench, who's deciding what is and what's not there. The real problem is holding a separation of church and state. Not only was that not in the Constitution, but that was a letter from Thomas Jefferson that was quoted by Hugo Black, who was a former member of the Ku Klux Klan, a very anti-Catholic a member of the court. So the whole issue really is personalities that's, on the bench, 9 individuals who were elected and accountable to no one, who have a life tenure.
That's right.
And once they're on there, once they go through their sort of kabuki dance of confirmation,
You're
as
absolutely
Megan
right.
Payne said.
No, you couldn't be more right. I talk to people about electing the president, and I say to them, what's your issue? They're like, I just like this guy. I just like that guy. He's going to be gone. And I don't just mean Barack Obama. I mean any of them. In 2012, the Republican that's going to come in. They'll only be there 4 or 8 years. The person that they appoint to the Supreme Court is going to be there when your sons' sons are born, or your children's children are born. We have John Roberts, Sam Alito are appointed not just because of their brilliant minds, or not just because of their political beliefs or their belief in the law, but how old they are. The fact that both these men were in their mid-50s or younger, they potentially could be there for the next 30 years. And it is important when we look at electing a president to look beyond their policies, but look to what their agenda is with the court. Now, this is one of the most dangerous things. You ask the average American about the Supreme Court, and they don't know anything. They know beyond nothing about the Supreme Court. In one CNN poll, they asked a group of people to name a Supreme Court case that was decided that was decided by the court. They couldn't name any. Couldn't name one. Marbury versus Madison, Roe v. Wade, Miranda versus Arizona. They couldn't name any of these cases. This is a problem. Most people don't know how many justices are on the Supreme Court. Most people don't know the tenure of the Supreme Court. Most people don't know the idea that a name of a person on the Supreme Court. These people are more powerful than the President of the United States. They're unelected, they're unaccountable, they're there for life, and there's no accountability to us once they go through the kabuki dance of the nomination process. Barack Obama's been in office for 2 years. He's already put 2 people on the court. We'll see how that looks going forward. If you like the appointments that he made, he's your guy. If you don't like the appointments that he made, we need to consider that in 2012. And I'm not here to give a campaign speech, but I mean, that's one of the main reasons why we elect the President of the United States, and that is to put justices on the court. And you hit the nail right on the head. They are going to interpret these words, and it's what we look at how they interpret these things. If you believe that a child in a failing school district should stay another year because maybe the school will figure things out, then put the political philosophy of the 4 people that voted against Zellman versus Simmons Harris on the board. Put more of those people on the board. If you think that your child shouldn't have to sit through a school year hoping that things will get better, then put the 5 majority on, and people that believe in that philosophy. And, you're 100% right. The court is so important to us, and what they do really defines the law. We saw that in any one of these issues, not just religion. The war on terror. There were 5 cases that have come up before the Supreme Court involving the war on terror. You know who won every single one of them? I'll give you a hint. Not George Bush. If you like that, if you like the way that George W. Bush was trying to govern during the war on terror during his campaign, then those are the justices that you're going to put on. I think we need to consider the court more than we do.
On Engel versus Vitale, the son of Madeline Mary O'Hare was in New York in 1990, visiting various churches because he became a pastor. He's now a Christian.
Okay.
So he's the one that was involved in the case.
Yeah, New Hyde Park School District actually was. Just talking about Engel versus Vitale.
Yeah. Anyway, in speaking, he was on a radio talk show in WOCA, talking about how back in the 1920s, he and his mother and all her group were all involved in communist cell groups, and that they talked about how Supreme Court justices were being groomed for the Supreme Court for the purpose of taking prayer out of schools. And that when it came to 1960 or 58, whenever they brought the lawsuit, they were already prepared. They were asking for cases. They were in the Supreme Court waiting for it. They wanted it to happen. And I personally believe that the regents in the state of New York deliberately created the prayer so that they could bring the case.
It's possible. I mean, there are a lot of cases. She's saying that essentially Engel versus Vitale was a case, it was like a setup case to kind of get prayer thrown out. There were actually 26, a majority of states filed briefs with New York supporting the school prayer. So this is a completely counter to public opinion, as I said before, the outcome in this case. But it's not unheard of that test cases go up. Griswold versus Connecticut, one of the most important cases of the 20th century involving the right of a married couple to talk with their doctor or someone in prescribing birth control, which has essentially created the right to privacy, which essentially is the precursor to Roe v. Wade. It's a test case. How does the police department know that a doctor is in a doctor's office prescribing this medicine? Well, it's a test case. Planned Parenthood of Connecticut called up and said, at this time tomorrow, we're going to prescribe this drug. Brown versus Board of Education is a test case. It is a case that there was a legal strategy from the NAACP, and I'm not saying that this is wrong. You know, we just have to, in the case of Griswold versus Connecticut, you know, this is part of the history of these cases, though, that there is a legal strategy. Many of the death penalty cases are a legal strategy. The abortion rights cases, it's a legal strategy of the right to life movement, and there's nothing wrong with that. But it is part of the history of these cases.
I'm sorry to talk about legal strategy, but it's also a legal agenda on the part of the court. In Griswold versus Connecticut, William O. Douglas said there's a right to privacy emanating from penumbras within the Constitution, which
yeah, the right to privacy is another like 2.5-hour lecture. That is right. Essentially, here in all these, we can at least point to clauses in the Constitution.
Well,
when we talk about Griswold versus Connecticut, they make it all.
Well, it's a handcrafted right, because that is the basis for abortion 8 years later with Harry Blackman.
Why don't we, if anybody has one more, we could take it in the back, sir. Right.
That's not anything in the Constitution, right? That it became tradition. Is that what happened?
Well, it became tradition until Reynolds versus United States, which he said, hey, legitimate, that clause about legislative action cannot touch opinion, but it can touch action. That's right out of that letter. On the back of the car that we gave out, that's right out of Thomas Jefferson's letter. Also, the wall of separation, we do see that, as someone had pointed out also in the Everson case. He says there is a wall of separation. And once the Supreme Court, in their opinion, says there is a wall of separation, they are charged with interpreting the Constitution. Their interpretation of the Constitution is the Constitution until they interpret it different or until a constitutional amendment says something different. So essentially, because of their unique role, their unique role of interpreting the Constitution, which by the way they gave to themselves as well in Marbury versus Madison, that's not in the Constitution either, that the Supreme Court is the final interpreter of the Constitution. That's nowhere in there. They found that in Marbury versus Madison. We're going to be the ones that decide what the law is. But essentially, once the court says it, it's what the Constitution is until they say something different or the Constitution is rewritten. Thank you very much for having me down here.